Good afternoon, everyone. This is South African Bar Association presentation. As you are aware, the South African Bar Association hosts a weekly event at no cost to participants and viewers to improve the skill sets of the legal profession. This initiative is aimed at making a fundamental contribution to developing the skill set of all and any persons who represent the South African public in our courts. It is my honor and privilege to introduce our eminent speaker today. Our speaker today is Advocate Bart, currently a practicing advocate at Oxford Chambers Advocates and an expert on labor law. Advocate Bart shall be addressing us today on a topic titled, Can Employees Make COVID-19 Vaccinations Mandatory for Employers? We are further honored and privileged to have Acting Judge Romeo Ntambeleni to conduct the welcoming and conclusion of Advocate Bart. A few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Accordingly, during the address, all participants shall automatically be muted. If a participant has a question, simply raise your hand using the Microsoft Teams platform. During the question and answer session, please restrict questions to the speaker relative to the topic under discussion and only pose such question when called upon. Without any further ado, I now hand it over to Acting Judge Romeo Ntambeleni to conduct the welcoming. Over to you, Romeo. I think your mic is muted. Just bear with me.
Can you hear me? AJ?
I can hear you now. Thank
you very much, AJ, for this opportunity, and a good afternoon to everyone. Thank you again for this wonderful opportunity to introduce our esteemed guest today. It's a great honor for me to introduce our founding member of the South African Bar Association, Bart. But in short, Bart, prior to joining the South African Bar Association, and he held chairs and also risk group. And then prior to doing that, he was a senior commissioner at the CCMA. He has more than experience, but in terms of Advocate Bart has a PhD from UNISA. He has CPIR from Stellenbosch, and he has got HDE and HDE from UWC, and he also has an honors in labor law from University of Johannesburg. So you can see that we are dealing with a very esteemed person with good experience in labor, and we are going to actually enjoy this talk, and this is a very important talk at the time that we are actually at now. Now, without further ado, I give this platform to Advocate Bart. Thank you very much, AJ.
Thank you. Over to you, Advocate Bart. You can just kindly unmute your mic and your video.
Thank you so much, AJ, and thank you again, Romeo, for your kind words. And to all the participants who've taken the time to log in this afternoon, thank you so much. I trust that we will have a fruitful few minutes together, and thereafter we will have a brief discussion, and then we'll leave it at that. So this afternoon's discussion is to dovetail the session that we had last week with Professor Shabir Mahdi. He dealt with the issue of COVID vaccinations and whether there may be lingering doubts or questions or queries. And I thought it very appropriate to this week continue where he left off, except we're dealing with a legal issue. and that being, can employers make COVID-19 vaccinations mandatory for employees? The structure that I intend to follow in addressing the topics are, insofar as today's session is concerned, the following topics will then be discussed, namely the effects of the COVID-19 pandemic, the nature of the South African workplace. Does COVID-19 constitute a national health emergency justifying the interference with fundamental rights? The principles set out in our case law and the circumstances that ought to prevail in order for vaccinations to be made mandatory. Now, the effects of the COVID-19 pandemic, I think all of us present would be able to attest that the COVID-19 pandemic has caused immeasurable, if not inestimable, devastation to the South African socio-economic landscape. Insofar as the labor market is concerned, it has been particularly badly affected. We have seen unprecedented job losses. We've seen closure of businesses. We've seen large-scale layoffs. We've seen decline in productivity. And we've seen increased use insofar as sick leave is concerned, where sick leave entitlements have been exhausted. And that is a direct effect of what COVID-19 has done. The only available means of defense against the scourge of the disease prior to vaccination was a combination of personal protective equipment and personal hygiene. With the benefit of science, our scientists now tell us that the best strategy against the COVID-19 pandemic is vaccination. And in essence, the reality that beset or before all of us insofar as COVID-19 is concerned for South Africans is there are one of 5 possibilities at play in South Africa and in fact all around the world and insofar as we get to COVID-19. The first is there are some South Africans who will never contract COVID-19. That is a reality. It's possible but highly improbable. The second possibility is the majority of South Africans will at some point or another contract COVID-19. The third possibility is that the majority of South Africans who contract COVID-19 will recover without being hospitalized. The fourth being a smaller percentage of those who contract COVID-19 will be hospitalized and will recover. And then lastly, and the saddest possibility is that some South Africans will in fact die from COVID-19. Now, it's in order to mitigate against the effects of possibility 4 and 5 that vaccines and vaccinations are regarded as increasingly important. Now, the South African workplace, we found that in South Africa we have 2 types of workplaces. The first being that we have got unionized workplaces where workers are organized and belong to particular trade unions, and you've got workplaces that are not unionized, they're non-unionized workplaces. If an employer is to get to the point where a decision to implement a policy that would make COVID-19 vaccinations mandatory in the workplace, such a policy would constitute a new term and condition of employment. And where new terms and conditions of employment are implemented or to be instituted in a unionized workplace, you must do it by way of collective bargaining, meaning the parties must sit and jointly discuss and bargain on the implementation methodology, strategy, etc., insofar as the implementation of the new policy is concerned. In non-unionized workplaces, you'll have implementation by way of consultation for purposes of information sharing, not joint decision-making or collaborative decision-making, as would be the case in dealing with unionized workplaces. Now, a decision to make COVID-19 vaccinations mandatory would result in a competing of fundamental rights. And what are these? Firstly, Section 12 of the Constitution, as captured in the Bill of Rights, provide that every person shall have freedom and security of the person. Subsection 12(2) says everyone has the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction, to security in and control over their body, and C, not to be subjected to medical and scientific experiments without their informed consent. Section 12 provides, therefore, in context, that every person has the right to make decisions on health and medical interventions and treatment that affects them, which must by implication include the acceptance or rejection of the vaccine. Similarly, Section 15 of the Bill of Rights provide, and insofar as the individual's right to freedom of religion, belief, and opinion, that everyone has the right to freedom of conscience, religion, thought, belief, and opinion. And again, Section 15(1) provides in context, therefore, that every person has the right to freedom of conscience, religion, thought, belief, and opinion, and that that right can also be interpreted to encapsulate the freedom of acceptance or rejection of the vaccine. However, all the constitutional scholars among us would know that Section 36 of the Constitution provides for the limitation of constitutional rights to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, freedom, and having regard to A, the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and lastly, a less restrictive means to achieve the purpose. Now, Section 8(1) of the Occupational Health and Safety Act provides that every employer shall take reasonable measures to ensure that the health and safety of employees in the workplace. What Section 8(1) of the Health and Safety Act provides in summary is that employers have a duty to ensure the health and safety of employees, and in failing to adhere to that duty attracts a criminal sanction, or has at least the possibility of attracting a criminal sanction. The Act goes further to state that it requires every employer whose employees interface with the public to take reasonable measures to ensure that interface does not endanger the health and safety of the members of the public. This brings us then to the question, does COVID-19 constitute a national health emergency, justifying the interference with fundamental rights guaranteed in the Constitution? Now, in as far as commenting on the extent of the public health emergency that dawned with the with COVID-19, it is true that there's never been a time in South Africa where government intervened to the extent that it has in restricting public liberties, movement and observance of health protocols in relation to a health emergency in the manner that we've experienced in recent times. In fact, it's unprecedented. The COVID-19 pandemic has had a detrimental impact on the economy, manifestly experienced in the labor market, as I've expressed and said earlier. We have and continue to lose work colleagues and family members on a frequent basis. I would hazard a guess that of each of the participants attending, we either know somebody directly or personally who have either succumbed or have been affected by COVID-19. Now, if it is true that mandatory vaccination can, either in the economy as a whole or in the workplace, result in employees being protected from serious, if not fatal, illness, and enable the perseverance of jobs, or acquiring jobs in an already depressed economy, then mandatory vaccination should be encouraged. Now, on the 11th of June, and this is extremely important for employers to note, on the 11th of June, the Minister of Employment and Labour published what was called an amended consolidation direction on occupational health and safety measures in certain workplaces. We refer to that as the direction. And it's effective from the 11th of June 2021. Now, this particular direct is very instrumental in understanding how the issue of mandatory vaccination is to be approached. The direction provides guidelines pertaining to social distancing, COVID-19 symptom screening, wearing of cloth masks, and the importance of ventilation in the workplace. Then section 63B, Roman numeral 3 of the guideline, provides that where an employee who presents with COVID-19 related symptoms is excluded from the workplace, the employee is entitled to sick leave. When this sick leave is exhausted, the employees are entitled to illness benefits in terms of Section 20 of the Unemployment Insurance Act. In the previous direction, a claim could be made in terms of COVID-19, the TER scheme, when sick leave has been exhausted, but this is no longer available under the amended direction. The direction makes provision for additional considerations relating to the vaccination of employees in the workplace. Now, what does it specifically say about vaccination of employees in the workplace? Section 3.1a, Roman numeral 2, provides that every employer must undertake a risk assessment within 21 days of coming into force of the direction. The risk assessment must stipulate, among others, whether the employer intends making the COVID-19 vaccination mandatory for its employees. If so, the employer should identify those employees who must be vaccinated due to risk of transmission through the nature of their work or the risk to contract COVID-19 due to their age or comorbidities. So this is a very important provision insofar as the amended directions are concerned. It carries on that the employer must develop a plan or amend an existing plan which outlines the measures that the employer intends to implement relating to the vaccination of its employees. The direction makes it clear that when implementing such a plan, employers must consider the employee's rights to bodily integrity as well as the right to freedom of religion, belief, and opinion. The plan must take into account the guidelines contained in Annex C of the direction. In terms of Section 4.1.1, it provides that employers must provide workers with information raising awareness on the nature of vaccines to be used, the benefits associated with the COVID-19 vaccines, the contraindications for the vaccination, and the nature and risk of any serious side effects such as severe allergic reactions. Section 4.1k states that employers must give administrative support to assist its employees to register on the electronic Vaccine Data System Registration Portal. Section 4.1 provides that employers must provide employees with paid time off to be vaccinated, and an employee must provide proof of the vaccination. So those are then in essence what the requirements under the amended health and safety measures are. Now, what are the principles set out in our case law thus far? At present, our courts have not as yet had the occasion to decide on the issue of compulsory vaccinations, but it's only a matter of time before it does so. There are, however, cases where the courts have already expressed itself on the proper application of Section 12 of the Constitution, the section that I've referred to earlier insofar as bodily integrity and the right to make decisions. In the matter of Minister of Safety and Security in another, with his GACA, the court relied on the public interest and applied what we call the balancing act of rights to conclude that the respondent was forced to undergo surgery, albeit that he never consented to the surgery. So what was important in this particular case, which you could read at your leisure, is that the consideration was not so much the person's inherent fundamental rights, but rather the public interest that applied. Similarly, in the matter of Minister of Health in the province of the Western Cape versus Goliath and others, the court compelled the surviving respondents to receive treatment for tuberculosis against their will. Now, in both these cases, the overriding decision and the overriding consideration for the court was the fact that the public interest outweighed the right to bodily and psychological integrity of individuals. This brings us to the question, therefore, what are the circumstances that they ought to or must prevail in order for vaccinations to be mandatory in the workplace? Firstly, there must regard must be had to the conditions set out in the directions, because that gives us the almost the subordinate direction insofar as what the law provides for. So the next issue is, do employees in a particular workplace interface with the public? If the answer is yes, then an employer must take reasonable steps or measures to ensure that that interface does not endanger the health and safety of the members of the public. Following to that is, does vaccination constitute a reasonable measure? Now, the mere fact that the government's national program of vaccination is premised on the fact that vaccination is one of the primary measures for combating the pandemic, it is further augmented by the provisions in the directions, meaning vaccination does constitute a reasonable measure. So, in essence, an answer to the question, therefore, is, can employers make COVID-19 vaccinations mandatory for employees? The answer is yes, subject to the following. Firstly, complying with requirements set out in the directions. And if any of you would like a copy of the set of directions, we can make it available to you. We'll publish it on the website. But most importantly, there must be a basis on which the setting out of particular justifiable grounds relevant to that workplace must be clearly discernible. Meaning, in a particular workplace, it may very well be found that it would be appropriate to have a number of employees vaccinated, giving a particular justifiable basis, but in that very same workplace, there might be circumstances which would not warrant employees in another department to be subjected to mandatory vaccination. where the threat of transmission is proportional to the increased number and frequency of contact, it's an indication of the extent to which, under those circumstances, the vaccination may be warranted or regarded as mandatory. So in essence, the question is, what is the extent of the risk and how do we minimize the risk in relation to what is set out in the directions, the frequency of contact and the number of contact, and whether or not there are justifiable grounds relevant to that workplace that would recall or require differentiation for the purposes of administering the vaccine. Right. AJ, thank you. I see that there is a question. I'm going to deal with questions now to the extent necessary.
Thank you so much, Bart. Before I get to that, can you kindly stop sharing your screen? Thank you so much. All right, Advocate Bart, I think I can speak on behalf of all the participants as well as those that will be watching this at their leisure when I say that your address was exceptionally informative and relevant. I have now opened a platform for a brief question and answer session. By way of a reminder, those that have a question, simply raise your hand using the Microsoft Teams platform, and when your name is called, simply unmute your mic and video to pose your question directly to Advocate Bart Ford. The first question is from Advocate Motebang. Advocate Motebang, you can simply unmute your mic and video.
Advocate Bart. Hello?
Yes, Counsel, I can hear you.
You know, I'm saying we truly appreciate for a very informative presentation, but however, I just few questions that I want to ask specifically in relation to constitutional jurisprudence in relation to this issue. One, in the case of Shabir Sheikh, I think versus SABC or DA, if I remember quite well, I'm not quite certain about other parties. But the issue in that case was the issue of the conflicts of the rights. One was saying that right to a fair trial or privacy. One was also dealing with the public interest. So it's a question of the conflict of rights. Why I'm asking this question, we have individual people who have got right to life, you understand, against that of the right that you have just spoken about, the bodily integrity, privacy, and the likes. Number two, on the conflicts of rights. That's the second point. First question. The second question is, in the first constitutional case of state versus Zuma, and subsequent to that, state versus Makwanyane and state versus Muhlongo, three of them were quite explicit, actually, on dealing with the proper interpretation of the provision of the Bill of Rights, and that the Bill of Rights ought to be interpreted purposively and generously. That's number one. And also in State versus Makwanyan, what then Judge President Chakelson said dealt with the principle of proportionality test, where the applicant ought to show that, demonstrate that your right has been infringed. Then against another one who said that the right, is it reasonable and justifiable in limited and open democratic society, and also on those 5 factors, but the most important part, it's less restrictive means. So the question primarily is that how then do you strike the balance between the two? I've got a right to life, and also you have got right to bodily integrity, in order for one to be able to balance the rights between the two, because both of them are protected by the Constitution. That's a right. That's what I wanted to ask. I don't know if it's clear, but
yes.
Thanks.
Thank you for that. So in essence, the principles that you've referred to in Shabir Sheikh and State versus Zuma and Makwanyane, they all seem to be saying, and so far as my reading of the authorities are concerned, seem to be saying the same thing. And that is simply that where it comes to an individual's rights as provided for in the Bill of Rights, that under exceptional circumstances should a right which befalls a person under the Bill of Rights be interfered with, unless it could be demonstrated, and it must be manifestly demonstrated, that in fact the limitation thereof can't be achieved by means of a less restrictive manner in which to give effect to that right, firstly. And most importantly, that when a balancing exercise of rights is concerned, that it must be that the public interest, insofar as what one would regard as a situation such as that we have in COVID, where you have a national pandemic, which could be regarded as of such severe consequences that it constituted a public health emergency, that if one has to balance the manifest impact of individual rights versus the public health emergency, then one must say which of those rights ought to rate higher or more, or ought to be considered more important in an open and democratic society underscored by rights and freedoms. I hope Mutabanga managed to answer your question, but I see there's another question from Peter.
No, thanks a lot. You did, Kaze.
Thank you so much, Bart. Peter, you can simply just unmute your mic and your video.
Thank you, Advocate Ford. Can you hear me?
I can.
Okay. Thanks very much for your presentation. I'm a practicing labour attorney in KwaZulu-Natal. And one of my questions is when you're in a unionized workforce, you have the obligation to engage in collective bargaining. Now, that's all good and well, but it seems that suggestion is in conflict with the directions that have been issued by the Honourable Minister, in that it leads us into a situation where the employer now is obliged to negotiate with the trade union an issue of workplace discipline, because we all might agree or disagree as to the severity of this pandemic that is now plagued our country and the world at large. But how do we overcome resistance at the collective bargaining table? And if unsuccessful, then the employer is unintentionally placed in a position where they fall foul of the directions issued by the Ministry of Labour. And I can just see, a mutual interest issue coming to the fore, and then the resultant consequences that go with that. I know I've raised several issues in my comment now, and I'll leave it to you to see if you can find a way through the muddy waters.
Peter, I think what you're raising is quite important. Can one ever be placed in a situation where you're being obligated to bargain? So what the directions do, insofar as the amended direction, it's in fact requiring that an issue of discipline becomes a matter for collective bargaining. Now, you and I know that discipline or matters pertaining to discipline ought never become a matter for collective bargaining at all. Now, I think the way in which it's approached is in essence, my reading of the regulation is as follows. There is a common understanding that we all need to do something about this. And what the minister is intending to do is to see, can we not get the parties together to say that there appears to be a benefit for us pursuing a basis on which vaccinations ought to be done or introduced within the workplace. The difficulty is, do you introduce it as a way of saying this is a policy for purposes of implementing a new term condition of employment, Because if you do that, then you're in fact raising a collective bargaining issue that ought to have been come about by the parties themselves. But in this particular instance, the minister is saying, I am going to introduce the topic and allow the two of you as collaborative parties to try and make some sense out of it. Because in essence is, and if you read the amendments, it deals with what to do, how to approach it, in order to get a maximum buy-in, and to the extent that there are employees who do not buy in, how that process ought to unfold in order to ensure that employees are not subjected to discipline. So it is a means, I suppose, by the minister to try and get the parties to talk to one another, and accepting, of course, that a duty to bargain cannot be enforced on any of the parties. Peter, that's as best as I've seen it, but I think one must probably see it from the point of view that the interest of trying to make good out of a very, very difficult situation is what promoted the pursuance of what the minister set out in the regulations. That's all I can say.
Yes, Advocate Ford, I agree with everything that you've said. I would like to just put my comment on that, is that I feel it would be incumbent upon the Honourable Minister of Labour to then announce this on national media, formal media, saying, country, employees, this is the problem, and this is how we need to respond to our employment responsibilities, which extend obviously to the public and the public interest and our homes and families, etc. So if it has to be introduced by the employer, going to the employee and saying, listen, Mr. Trade Union, the minister said this, that, and the other thing, is an inherent distrust with all of these collective bargaining meetings that start along the latter description, as opposed when the government makes a proper formal announcement, hang on, here are the directions, and this is what your employers are going to be coming to you with.
Okay. Yeah, absolutely. And just to add before you go, I think a lot more need to be done for employers to know that, in fact, the amended consolidated directions are available. And in fact, there should have been robust discussion in all workplaces about what the amendments say, and the extent to which, especially the unionized workplaces, would be affected by it.
Yes. Thank you so much.
Good.
Bye-bye.
You're welcome.
Thank you so much, Advocate Bart, and thank you, Peter, for those comments. Advocate Bart, I have a question. From your address on whether employees can make vaccinations mandatory, you answered positively in that regard, further submitting that naturally, with adherence to the regulations such as social distancing, and more particularly the justification element, of which I submit can be varied widely. The justification element is where my question, or rather clarification, emanates from. Now, in asking my question, I shall place before you two exceptionally extreme-ended scenarios and ask you where you would find the middle ground to such. The first scenario being an employee who is a construction assessor, works primarily from home, however, on occasions, say once every month, will go out into an open field and conduct assessment where he seldomly encounters anyone. The second scenario being an employee who is a health worker who is exposed to many people on a daily basis, often the elderly and others who are at risk of severe underlying medical conditions. Now, naturally, in the first scenario, it would not be justifiable for such employee to be subjected to mandatory vaccinations. However, the employer in the second scenario, it would be justifiable to submit such employee to mandatory vaccinations. Now, we find ourselves somewhere in the middle of those situations. So my question to you, in your view, what would your advice to the employee be in circumstances of such?
Thank you, AJ. I think that's a very important question. So in order to subject employees to mandatory vaccination, there must be a justifiable reason to do so. Like we've seen in the case law that I referred to earlier, there was the justification there was the public health concerns. Now, in the absence of a justifiable reason, any instruction to subject an employee to mandatory vaccination would be arbitrary. And that is what the amendment, in fact, speaks against, of any form of arbitrariness. Now, insofar as your first example and scenario where you have the construction assessor who works from home and if not from home in an open field, there it is clear that insofar as the concerns raised in terms of Section 8.1 of the Occupational Health and Safety Act, that would not be applying, because in Section 8.1 there is no direct contact with the public. It's also clear that insofar as his interaction with others are concerned, whether it be the public or other employees, that it's even further minimized. And that minimization is in relation to the fact that he doesn't have contact with him, he works from home. Under those circumstances, I cannot see a justification for mandatory vaccination. In the circumstances such as scenario B, where in fact the elements that apply there would be exposure, frequency, and risk. Where your exposure is increased, proportional to your frequency thereof, it has a knock-on effect on the risk, and under those circumstances, an employer would be justified, such as in your scenario with medical personnel. I can think, for instance, in such circumstances where you have a domestic employee who looks after small children, or you have in a situation where you have a palliative care worker or a person who looks after the frail and the sickly, who interacts with them on a regular basis, where social distancing protocols cannot consistently be complied with, that under those circumstances, it would be justifiable for an employer to ask that the employee be subjected to mandatory vaccination.
Sorry, just on a follow up on that, right? Now, on the middle grounds of that, obviously we find I gave you two extreme ends of it, but what if we find ourselves as, say I am an employer, and I find based on this scenario, I find that a particular employee, it's not justified for that particular employee to come in, because hypothetically speaking, they don't come into the office that often, they're on the field and they don't come into the office that often. But what happened, and based on that assessment alone, I don't deem it justifiable for that particular employee. However, for whatever reason that it may be, that particular employee does happen to come into contact, which can happen on occasions, and how will we work through that? Now I heard you said that obviously case law is still to come into play, but what would be your opinion on that? Because if we just have it open-ended, or if we rather have, my submission is that it should be universal, that it should be mandatory universally, and it shouldn't be up to the employer's discretion.
Yeah, AJ, I understand where you're coming from, but in as far as an employer were to adopt a policy where you apply it universally, or the term that I prefer to use is that you apply it consistently throughout the business, one must look at the specific individual, the role that the employee plays within the workplace, and then have regard to it as to whether or not under those circumstances it would be justifiable to have that person be subjected to vaccination. Let me give you an example. My brother, for instance, works from home. He works for Massmart, and he works as the workforce skills plan assessor. He works from home, and he has no interaction with his colleagues at work on a direct interface person-to-person basis. His circumstance is entirely different to a situation where you have a teller who interacts with, in one of the Massmart stores, with members of the public who she interacts with as they come past her, and she tallies their bills and scan their products. So one would need to look at, if there's a differentiation, how that differentiation would apply. Because unless you can justify, your decision would be arbitrary. Thank you. I see Bengal is with us.
Thank you so much, Bart, for that. There's a question from Acting Judge Romeo Ntambalani. Romeo, you can simply unmute your mic.
Okay. No, thank you very much, Bart, for such an informative conversation. And I want to confirm and say to you, I also lost a sister through COVID. So this is a very serious issue that we are talking about today. And I want you to to address the point of refusal to vaccinate. If you refuse to vaccinate, and also dismissal for for refusal of vaccination.
Yeah, thank you.
Because if a person is raising the grounds, the constitutional grounds that Rameli and yourself, and they are really raising religious grounds that they don't want to vaccinate on the basis of religious ground, and you cannot apply limitation insofar as their religious consents are dealt with, and they are in a situation where they are exposed to other people. How are you actually going to deal with that? Because it's quite important. It's a quite important right of religious beliefs of a person. And when are you going to say you're going to dismiss? What criteria are you going to use for dismissal? Dismissing such a person, and also the issue of refusal being to be vaccinated based on religious ground or any constitutional grounds that has been raised that you have canvassed in the beginning of this conversation. Thank you.
Right. So Romeo, firstly, we need to understand at what point we speak about refusal. Right. So
yeah.
What the code envisages is circumstances where it is concluded that in a particular circumstance, it is justifiable for an employee to be subjected to mandatory vaccination. Meaning the groundwork, so to speak, has been done, and these employees have been identified as employees who ought to be vaccinated, or should make themselves available for mandatory vaccination. Now, paragraph 4 of the code of the amended direction deal with that. It says that the employee must be engaged, and the employer must consider, short of following a disciplinary route, what other avenues could be explored short of following the disciplinary process. But let's assume, for purposes of the exercise in your question, is that the employer has set out justifiable grounds. The employee is not adhering to those grounds, and in fact still feels that the basis on which the request to have him or her vaccinated is unfair and unreasonable. Now, remember, there are only 3 reasons that an employer can ever terminate an employee's employment. It must be either for misconduct, for incapacity, or for operational reasons related to retrenchment. So we now know it has nothing to do with retrenchment, which leaves us with it's either misconduct or incapacity. But it cannot be misconduct in this particular instance, it is simply the employee is no longer in a position to give effect to a condition of employment that is required by an employer. So it becomes a species of incapacity. So the short answer is one should try everything, and that the amended direction provide for, to accommodate the employee. But should accommodation fail, then the employer would find itself in a position where it may have to consider terminating employees' employment on grounds of incapacity. Thank you.
Thank you so much. Romeo, does that answer your question?
But I really answer you've answered. Yeah, it does. Thank you.
Thank you. Thank you so much. Bart, there's a question from Tingan. Tingan, you can simply unmute your mic and your video.
Good afternoon, Advocate. Thanks for the informative session. I really hold you as a professional in very high esteem. I just have two questions which I want to run by you. The first question is, it's not a legal question, it's just a information that we have in the public domain suggests that if you are vaccinated, it does not preclude you from contracting the virus. And I would assume it also does not preclude you from passing on the virus. So what would be the real basis for any employer to insist that employees vaccinate, or suggest that employees that are not vaccinated are putting others at more risk than the ones that have not vaccinated? Just from a logical point of view, is it not a loophole? Is it not something that can be argued from that angle? The second question, I just need your view. You would have heard in the news that the Curo group of schools has almost taken a position that if a teacher or an employee does not want to vaccinate, they will consult that employee and might actually retrench that employee, which borders on rendering them operationally not employable. So they would dismiss them based on operational requirements. What are the legal loopholes in that approach, given the response that you've just given now?
Well, thank you. Firstly, Dingaan, let me just qualify. I'm not a medical practitioner at all, so I can only defer to the scientists. And last week we had Professor Mahdi, who explained when this particular issue was raised as to if a vaccinated person can still contract COVID, that could be the rationale. And he explained that there is a reduced, it's not impossible, but there's a reduction in the possibility of a vaccinated person transmitting the virus and infecting others, but that the possibility is exacerbated increasingly in favor of employees who were not vaccinated. Meaning, if there are 100 people, if I give an example, that have COVID-19, that from amongst those who have in fact contracted the virus, the majority of them would have received it from those who are unvaccinated than those who are vaccinated. He explained further, and if you can, please go to the website and listen to that session last week. He explained further that the idea with vaccination is we're not vaccinating against against one's ability not to transfer the disease. We're preventing serious health ailments insofar as hospitalizations and death is concerned, because that will also have an impact on the employment labor market segment. Insofar as your second question is concerned, whether the Curo group can retrench a person for not subjecting himself to vaccination, I submit one must be careful in terms of how would you approach. Remember, the retrenchments would be regarded as an operational no-fault dismissal. And in a particular instance, it would be where if a person is required to meet a certain standard and the person is not able to meet that standard, and the standard being you need to be vaccinated in order to teach, that becomes the condition of employment, then I can't see how your failure to meet a condition of employment would be able to be regarded in the same way as an operational dismissal. But again, when we come to labor law, there are so many different interpretations to a singular set of facts. But I would be surprised that one would be able to pursue it via a retrenchment route.
Thank you, Advocate Bart.
Thank you, Bart. Bart, this is a question from Al Bogan. Al Bogan, you can simply unmute your mic and your camera.
Good afternoon, Council. Thank you for the informative session. I just want to put two questions to you. Firstly, what would the burden of proof be on an employee to show that the mandatory vaccination is not justifiable? And then my second question would also be, what is an employee's recourse in going about challenging a mandatory vaccination and then subsequently being dismissed for that very reason? Where would your starting point be?
Thank you, Lishan. So the first question is, what's the balance of proof that the employee would need to if I understood you correctly, to demonstrate that the decision is not justifiable?
Yes, that is correct.
So if an employee is of the view that the requirement that the employer places on him or her to be vaccinated is not justifiable, the employee would simply need to demonstrate that the employer's basis for concluding that it's justifiable is not reasonable. Meaning, one would need to look at obviously the specific set of facts that apply. Again, if I use the example of my brother, who works from home, who generally has very little contact with mass-marked staff, if there's a decision that he must be vaccinated, under those circumstances, you would then be able to demonstrate that none of the concerns raised in the amended directions or in the Section 8.1 of the Occupational Health and Safety Act applies, or that he places himself or others at risk, or that there's been no increased frequency insofar as contact which would expose him or others to risk. That will then be able to demonstrate that a decision to subject yourself to mandatory vaccination under those circumstances would not be justifiable. Now, the recourse that one would have is obviously if an employer was to say, well, I am going to terminate your employment because the basis for your refusal is unreasonable, and let's assume for the purpose of the exercise they terminate you based on insofar as my understanding would be for purposes of incapacity, then the employee would simply be able to go to the CCMA or the Bargaining Council with jurisdiction and say, well, I'm of the view that the basis for the instruction to subject myself is unfair and challenge it at that forum. That would be the approach that I would follow. I hope that answers the question, Lee.
Yes, thank you.
Thank you, Ed. Bart, there's a question from the brain. You can simply unmute your mic.
Good afternoon, Advocate. I've just got a few questions for you. There's families working in one household. Some may be working, from home. Some may be working for a department or for a company. So you do still get interactions between these people within a family communion. Then also, even if everybody is working from home in a specific family, you may still get contaminated when you are going and buying groceries. So you are still having a risk from being contaminated or infected. Within government in general, there is no longer a rule for us to just be Department of Health officials working in general. We are all working these days 100% basically in government, whether it's level 3 lockdown or not. Based on the fact that suppliers have to be paid, service has to be continued, you have to account for the money that is being provided, etc. So it's difficult to just isolate health because everybody is here at risk. Now, if you do get a person that are infected and a person that are been taking the vaccination, yes, you do get a minor risk for being infected by the virus, but you can still be infected because you will still get flu-like symptoms. With a person having a comorbidity, or comorbidity actually is the right word, if you aren't injected with the vaccine, your risk is so much higher to be probably, sorry for the word, dying by being infected by the virus. And even if you are injected for the vaccination, when you are a comorbidity, you will still get sometimes iller than another person, will just get normal flu-like symptoms. The other issue that I would like to ask you is also, how are you, if you're just going to do it from a labor perspective, how are you going to deal with the unemployed to get them vaccinated, because they will not be covered under this labor regulations because they're not employed. Even your farming communities. So I think we need to look at the general public and maybe from a health professional perspective in terms of the Disaster Management Act, maybe looking at a clause or regulation that we make it more justifiable for the concern of the general public to be the more interesting party, to be their rights, to be basically... sorry, can I continue?
Yes. Carry on.
Okay. It's just the general public is for me a greater concern in terms of the Constitution than an individual's right. And I think just more people getting the vaccine, the less likely we will get infected. So for me, the general public interest is for me the core here, and maybe looking more at the regulation from the Disaster Management Act. Instead of trying to look at labor relations perspective and forcibility, whereby some people are working from home and not working from home, it doesn't really matter, because I had a situation in my own household that whether you even working from home or not, your fellow people, my son, for example, were constantly in a very dangerous situation with Department of Justice being constantly exposed in the private sector with the regional court, district court, high court, and up until the time that they decided to try virtual platforms. My husband working at the Department of Health. Whether it is a situation of you being still exposed, even if you're a comorbidity. It is really a very catch-22 situation here.
So thank you so much for that question, Azit Aldridge. I'm not sure how to pronounce your surname. Look, I think to the extent that you're saying that even if you work from home, unless you work in such circumstances where you are not exposed to others, the risk that you would have whilst you're working in a formal office setting is in fact exactly the same risk that you would have at home, given the proximity and the frequency of contact. And if that is the case, then I think under those circumstances, the individuals in that household may very well amongst themselves get to the point where they say, you know what, albeit that we're working from home, we are in fact placing others at risk by our interaction with one another. And if one is infected, the other person may also become infected. So in that particular instance, whilst it might not be a requirement from a labor point of view, it might be from a person-to-person, ameliorative care for others in a benevolent sense that would cause one to say, look, under those circumstances, I suggest we should be subjecting ourselves to vaccination. And you're quite correct that the fact that you may be vaccinated, it does not mean you won't get you will not contract COVID. In fact, as we listened last week, is you may very well still contract COVID, except that your symptoms or the extent of the effect of the disease will be far lessened than what would be the instance if you're unvaccinated. As to whether the unemployed in the farming community, that is certainly something that the government at some point will need to give direction on as to what to do where the public interest should be considered by far the more important consideration than individual interest. I hope that answers your question. I think, AJ, we can do with one more question and then we'll call the session to an end.
Thank you so much. Advocate Bart, due to time restrictions, I have closed the question and answer session. I now hand it back over to Judge Romeo Tambuleni for the conclusion. Over to you, Judge.
Thank you very much, and Bart, thank you so much for giving us such a wonderful talk. You can see that if we continue with this talk, we can talk up until the cows come home, because people are very much interested in this burning topic, and I think we'll take it off this platform and also continue on another platform to actually share this important knowledge that you have shared today. So it's quite important. We want to really thank you for what you have done, and it shows that this kind of pandemic that we are facing now needs a collective effort, that all hands must be on deck. There is no one size fits approach. So thank you very much for your presentation today, and we hope that you will engage us further in future with very interesting and informative topics. And we really appreciate your time. We really appreciate you, and we hope that everything will still go well, and we'll have to hear more from you in the future. Thank you so much, Bart.
Thank you.
Thank you, Bart. Following on Acting Judge Romeo Tambuleni's advice, I think I can speak on your behalf when I say that should participants and or viewers have any burning question, they could simply email you and inquire and pose such question to you if you'll be willing to accept such.
Absolutely. Thank you. Thank you for your time. Thank you for your attendance.
By way of final conclusion, on behalf of the South African Bar Association, we sincerely thank Advocate Bart for his informative address and his time. We would further like to thank Acting Judge Romeo Ntambaleni for his exceptional welcome and conclusion, and obviously his time too. Appreciation to all those who have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.